For example, in the case of R and Secretary of State for the Environment, Transport and the Regions, the Secretary of State appealed against the declaration that his powers to determine planning applications were incompatible with the Human Rights Act 1998 Article 6. So, what was the issue that was in contention here? The dual role of the Secretary of State in formulating policy and taking decisions on application received created a situation whereby there is no independent and impartial tribunal. The Secretary considered that while his role in the process may be impartial, but maintained that there was adequate judicial control to safeguard overall fairness. The appeal was allowed as courts were able to exercise sufficient control over the decision by means of judicial review. The courts were only obliged to exercise control over portion of the role that concerns lawfulness of the decision and the adequacy of the procedural steps involved. It is worthy to highlight Lord Hoffman's remark whereby he stated that there is however another relevant principle which must exist in a democratic society, that is the rule of law. The principles of judicial review give effect to the rule of law. They ensure that administrative decisions will be taken rationally in accordance with a fair procedure and within the powers conferred by Parliament. Another case that we can look into would be R and Secretary of State for the Home Department ex parte Pearson, where the Secretary of State decided to increase the minimum period to be served from 15 to 20 years in a case where plaintiff had been convicted of a double murder of his parents. Following representation to the Home Office by plaintiff, the subsequent Secretary of State stated that the offence nevertheless warranted a term of 20 years imprisonment although aggravating factors had been taken into account in error. In addition, the Court of Appeal held that the Secretary of State had the power to use his discretion to review the decision of a predecessor if necessary. Plaintiff then appealed. Allowing the appeal, the Secretary of State was held not entitled to increase the tariff previously set as a minimum term for a life sentence prisoner. Therefore, the 20-year sentence was quashed. In addition, Lord Steyn has stated that the rule of law enforces minimum standards of fairness, both substantive and procedural. With the following two cases, it can be perceived that the rule of law is something that is highly regarded and looked upon with a judge to judicial review because to do otherwise will require us to compromise on the well-established constitutional arrangement in the United Kingdom.